Morena tātou. I'll just wait for everyone to join in to the Zoom link before we get started today. Morena, if you're just joining us, we'll wait a couple of moments to let everyone get into the Zoom link. Morena, everyone, will wait just another moment to allow the last few people to join our webinar. Tēnā koutou, tēnā koutou, tēnā koutou katoa, ngā mihi nui kia koutou katoa. It's my pleasure to welcome you to our seminar on the changes to credit laws. We're really sorry that we're not able to do this in person, and we want to thank you for taking time during these difficult days to spend this hour or so with us, listening to our experts talk about the reformed credit laws. We also want to say thanks in advance for understanding any Wi-Fi wobbles or technical glitches that we have. I'd like to hand over now to the Commission's Kai Whakahaere Māori, PJ Devonshire, who's going to do the honours of opening for us. Morena, PJ, welcome.
Morena, Sonia. Ngā mihi kia koutou, tēnei mihana kia koutou, te tautoko ngā mihi kia koutou, tēnei wā ko piripiri mai, ki tēnei tō tātou nei kaupapa o te wānei. Tēnei te kumihana tau hoko, te Commerce Commission, a mihana kia koutou. Mihana kia koutou hoki rungi ngā āhuatanga o te wā, ka tika tēnā ka mihi kia koutou I te rā reo o Fiji, a Bulavanaka kia koutou e tēnei wiki. I te rātu wiki ko te wiki o te reo Māori tēnā, a tēnei wiki ko te wiki o te reo o Fiji. Mihana kia koutou. Hoi anō, ki rungi tēnā māku, te tūwhera tēnei o ngā hui, I raro tunu I te manaakitanga o te wāhinaro. Mōreira, mai e te tipua, mai e te tāwhito, mai e te kaoiariki, mai e tāwhiwhiati ki a koe e rongo whakairia ki runga kia tai mai te manaakitanga, kia tai mai te rangi Māori, ki runga ki tēnei hui, mai te timatanga tāno ki te mutunga, haumi hui e tā ki e tēnā koutou. Kā koe, Sonia.
Kia ora, tēnei te mihi kia koutou. So we have an interesting couple of hours ahead of us as we discuss the changes to the Triple CFA, which, as you all know, is the Credit, Contracts and Consumer Finance Act. Today is about helping everyone to better understand the changes that are happening, but also for us to hear from you about how we can provide better guidance to lenders and answer your questions. Today, you'll get the opportunity to hear from our credit leaders, including Louise Unger, who's the General Manager of Credit, and John Lyle, our Credit Investigations and Compliance Manager. Today, you'll also get to hear our credit experts, investigators and lawyers, who include Miriam Schumacher, who's going to discuss the changes to fees and advertising, Wendy Blennerhassett, who will cover off due diligence and certification, Crystal Uden is going to talk about disclosure, Jean-Marie Grobler will talk about the complex area involving responsible lending, and then Lizanne Gibbs, who's going to talk about the new and improved Red Flags resource the team have created just for you. And then our friends from the Dispute Resolution Services are going to wrap up with a short session on raising complaints. So something that's really important to note is today is just stage one of our information sessions. Next week, you'll receive an invite to some in-depth webinars, 45-minute online sessions on each of the 6 different subject areas. And these will be based on your questions and featuring our experts. They're being held over the 26th and 28th of October. So we know these changes are significant and complex. So the follow-up webinars will dive into much more detail. And to make these really effective, we need to hear from you. We need you to tell us what you want to know about so that we can make sure that you have the information you need. So how do you do that? At the end of this session, when you close the window, you will be redirected to an anonymous survey. Pop your questions in there and they'll guide us as we develop the in-depth webinars. Now, before inviting our General Manager of Credit, Louise Unger, to speak with you all, I'll quickly go over some housekeeping. If you have a technical issue, please raise your virtual hand. It's under Reactions on the bottom of your screen, and we'll see if we can assist you in the chat function. Penny is handling our Zoom, and I'd like to introduce Penny now. Welcome, Penny, and thanks so much for helping us out.
Kia ora, Sonia, and kia ora tātou. If you have any questions during the presentation about the law changes and what they mean, please note them down and add them to the survey, which will pop up at the end of this webinar when you leave. As Sonia said earlier, your questions will feed into the information we provide at the in-depth webinars in a couple of weeks. So we're really looking forward to hearing from you.
Thanks so much, Penny. Thank you very much. And thanks for your technical assistance. And so now I would like to welcome Louise Unger, our General Manager of Credit. It's lovely to have you, Louise. Thank you so much for your time.
Thank you, Sonia. It's great to be here. E morena, everyone. So thank you for coming today. We're all very grateful you can take the time to come and learn about the changes to credit laws. And it's really important that the credit engages with you all as financial mentors and budget advisors. The work that you do is incredibly important as the interface between your clients as borrowers and lenders. So it's very important for us that we're able to provide you with the information that you need to assist and support borrowers in New Zealand. So thank you for the work that you do. So as you've heard, I'm Louise Unger, and I'm the General Manager of the Credit Branch of the Commerce Commission. And I've been in the role for actually just over 6 months now. So I was pretty excited to be given this opportunity to lead the Commission's end-to-end accountability for consumer credit, as it provided me with a much wider opportunity to drive what I feel like I've really been driving for many years, which is sustainable and effective compliance with the CCCF Act, which provides the right outcomes for consumers, but also takes into account the at times challenging aspects for lenders when implementing this legislation. So today is an opportunity for you to learn and to hear at a reasonably high level about core areas of the law that are changing. And as Sonia mentioned, you'll have the chance through the chat system to tell us what you want more clarity on and the areas you'd like to provide more education around. And where we can do this, we'll do it through the deep dive online topic sessions in a few weeks. So as mentioned by Sonia as well, today you'll hear about the changes to the law from experts from across our branch on 4 key areas. So it's responsible lending, due diligence and certification, disclosure, and fees and advertising. So by now, most of you may be aware that the start date for this upcoming group of law changes has been pushed back by 2 months, from 1 October to 1 December, except for certification, which came into force on 1 October. The reason will be no surprise to you all. And as you can imagine, the lockdowns have upset the timetable for lenders to make all of the necessary changes for them to be able to be compliant by 1 October. So some of you may be wondering about the Commission's enforcement approach and how we will be monitoring compliance. And on that note, I'd like to introduce you to John Lyle, who's our Credit Investigations and Compliance Manager. John?
Kia ora tātou. Thanks very much, Louise, for the introduction, and good morning, everybody. So as Louise said, I'm John Lyle. I'm the Investigations and Compliance Manager for the Credit Branch of the Commission. And so, since about 2015 and the law changes then and the introduction of, for instance, responsible lending, that's seen the Commission change from just having a few investigators in the credit area to one where we now have our own branch, and are fortunate to have Louise as our General Manager with all her background and experience with the CCCF. So as many of you will no doubt be aware, this round of credit law changes is extensive. Lenders have a lot of system changes to implement and new regimes to comply with, such as certification and due diligence, and you'll hear about those from Wendy shortly. These are big changes, and we'll be working with lenders to help them get it right. So in talking about our education and enforcement approach to the law changes, it's also helpful to keep in mind the Commission's role and responsibilities under the CCCF Act. So our priority is always to promote compliance with the legislation, and therefore also the new changes as effectively and efficiently as we can. The purpose of the Act is to both protect the interests of the consumers and also to promote and facilitate the fair, efficient and transparent credit markets for the benefit not only of the consumers, but also of the lenders who provide services in those markets. So following on from this context, the most efficient and effective thing the Commission can do as a regulator of consumer credit is to work as closely as we can with lenders to help them comply with the new laws. So what this means in practice in our approach to the new laws is a few things. Firstly, we'll have a significant focus on engagement and education in the lead up to the changes and also after the 1 December. We will continue to engage with lenders where we see their advertising or messaging is at risk of breaking the law or where there is the potential to cause harm to consumers. We also recognise that as lenders implement the law changes, they'll come across issues that may cause some uncertainty or challenges in relation to how they interpret or apply the law. This may also be in areas that we're not currently aware of. Some of you advocate for clients and work closely with lenders and are also likely to see lender conduct that does not seem right to you. We therefore encourage you to let us know about these things. Even a short email notifying us about your observations helps us to understand where we may need to provide further or clearer guidance for lenders or to help them comply by direct engagement. Secondly, we'll be enforcing the law from day one being the 1 December 2021. However, as mentioned earlier, the law change is extensive. So in line with our existing enforcement model, we'll be focusing on engagement, education and outreach to help lenders comply with the new laws. This doesn't mean we are going to go easy on lenders who refuse to comply. Our enforcement response is particularly driven by the factors of harm, the seriousness of the conduct, and also public interest. On the conduct side, we'll certainly be factoring in lender behaviour and willingness to comply with the new laws in our investigations, including and especially in the months after the 1st of December, whether an approach taken by a lender is in our view a genuine mistake or a misinterpretation of the new laws, and we'll factor that in. Thirdly, following on from these other points, if we do see widespread harm from non-compliance with new laws and or a lender's conduct significantly departs from expected behaviour, we'll not shy away from taking the appropriate enforcement action in those cases. So going forward, the introduction of the certification regime, which Wendy's going to talk about, will also will allow us to easily identify new lenders and ensure that they are made aware of their obligations under the CCCF Act. This responds to some concerns raised by the credit sector, including yourselves, that new lenders may not be aware of the various requirements set out in the legislation when starting out. So thank you. Razan's going to talk about red flags later, and I really encourage you to get involved in that program and help us to enforce the law. So thank you again for your time. I'll now hand back to Louise.
Thanks very much, John. So I'm now going to briefly speak about what we are seeing in the industry and our priorities. So firstly, high cost. So since the changes last year that introduced new obligations on high cost lenders, which probably most of you already know are those lenders which generally speaking offer loans with more than a 50% interest rate, we have had a significant focus on monitoring compliance with these new obligations. So there were originally around 30 high-cost lenders in the market, and quite quickly after the introduction of the new laws, these dropped to around 8. And I think there's now around about 3 lenders offering high-cost loans in the New Zealand market. So for those that exited the high cost market, we have monitored and will continue to monitor their fees to ensure that the reduction in interest rate does not lead to the charging of unreasonable fees. And we will also continue to have a focus on compliance with the high cost lending obligations for high cost lenders that remain in or later enter the market. So secondly, onto mobile traders. So given the changes that require mobile traders selling on credit to comply with the Act, it has been really important for us to have an education and monitoring focus on the mobile trader sector. So this work is ongoing and will continue through into the new financial year. Now onto responsible lending. So it won't be of any surprise to you that compliance with the responsible lending principles has been and will continue to be an important focus for the Commission because of the harm that clearly results from lenders not complying with these obligations. Compliance with the new affordability and suitability regulations will also be a priority focus for us. And our education and enforcement approach to these new requirements will be within the context just mentioned by John. And later on, you'll hear from Jean-Marie, who will take you through what is changing and how lenders will need to do affordability and suitability assessments from 1 December. And then lastly, our other priorities. So in terms of our other priorities across the ambit of the Act, we are intending on taking a flexible approach that enables us to pivot and be agile in relation to what we are seeing and hearing through the information we collect and are provided across the industry, rather than having fixed and inflexible priority areas. And this is where you providing us with information is so incredibly important, because data and intelligence is another priority focus for us. So the more we receive, really the more we can analyse, and then the more we can do in the market. And we will also have a considerable focus on our certification regime, as well as educating lenders about our expectations in relation to the director and senior manager due diligence duties. So that's it from me. I'm now going to hand back to Sonia. Thank you.
That's lovely, Louise. Thank you so much for taking time to speak with us today. Right, so now we're going to spend about 10 minutes with each of our experts going through the main changes that we've grouped to make it easier to understand them, because there's some quite complex changes contained within the legislation. So they are fees and advertising, due diligence and certification, responsible lending, and disclosure. We've also emailed everyone a detailed handout for each of these areas. If you didn't receive it, then email us at credit.advocacy@comcom.govt.nz and we'll send all 5 handouts to you. Just a note about the topic handouts. This is what we provided to lenders at the seminars we ran for them a few weeks ago, and they're available on our website. So we're sharing them and promoting them so people have got a detailed understanding about the requirements as a result of the changes. This way, you'll be able to see what we've said to lenders about the law changes and their new obligations. So after we hear about the key changes to the laws this morning, Lizanne will then introduce you to the new Red Flags resource, and that's been specially designed and co-designed with you to support you in your work. We've also emailed you an electronic copy of this document. Pop a note in the chat if you haven't received it and we'll get a copy to you. You can get hard copies by emailing us, and again, Penny's put the email in the chat for you there. I'd like to acknowledge that it's a long time to spend on Zoom, and we've tried hard to condense lots of information into this high-level webinar. And I just want to reiterate, this is the first stage in the information about the credit law changes. The questions you write up in the survey at the end will inform our webinars, which we're holding in a couple of weeks. We're also recording this session and the webinars, and we'll send you a link to the video in the next week or so. Now, I'd like to welcome Miriam, who's an investigator with the credit team here at the Commission. Today, she's going to talk to you about the credit reform changes that impact on lenders' obligations around fees and advertising. And I can see that Penny's just popped a link to the handout relating to fees and advertising in the chat, but hopefully it's also as an attachment in your inbox. Hi, Miriam, welcome.
Thanks, Sonia, and thank you everyone that's come along today. So I'll be talking about advertising and fees and some of the rules that have changed around that will come into effect on the 1st of December this year. So first of all, I'm going to take you through advertising, and I'm sure that some of you have seen ads for credit and have wondered if some of the ways lenders advertise is legal. So the CCCFA has a number of responsible lending principles found in section 9C, which lenders must comply with as part of meeting their obligations as a responsible lender. And one of these is advertising. And now some of the guidance in the Responsible Lending Code around advertising practices has been added to the advertising standards regulations.
So then, Miriam, what type of advertisements are covered under these new regulations?
So the regulations cover a lender's own advertising of their products and any advertising that they've authorised. The definition of advertising is also pretty wide and covers advertising that the public or a section of the public see. So for example, billboards and texts or emails with the borrower's name on it. And just to note on that last point, so direct marketing to people on the lender's database is considered advertising to a section of the public. So for example, situations where the lender uses a standard template and distributes a generic message to people on their database. Lenders must also ensure they have processes in place to help a borrower reach an informed decision and must properly assess for suitability and affordability. So their advertising can't be misleading, deceptive, or confusing. So for example, they can't suggest that the loan approval process is virtually instant and that they won't be asking any or many questions given their new strict affordability requirements coming into place. And lenders' advertisements must also comply with the advertising standards set out in the new regulations. So I should note here that there's a useful section on the advertising in the Responsible Lending Code, which was refreshed earlier this year. And the regulations, although they're new, really just outline what we already consider to be good practice under the current law. And they set out some helpful do's and don'ts to assist you.
Oh, that's so handy. And I see Penny's popped a link in the chat to the Responsible Lending Code. I know most of our people watching today will be well familiar with it, but sometimes it's handy just to have it there right in front of you. So Miriam, when we think about the must-dos for lenders, when it comes to advertising, what are the key things that they have to consider when they're placing ads or creating ads?
Okay, yes. So look, if lenders advertise a payment amount such as $20 per week, they must also state the total payments that will be payable if that can be worked out. If that can't be worked out, lenders need to state the annual interest rate that will be applying under the loan. There's also now regulations around the information lenders must provide if they advertise an interest rate. And if lenders advertise interest-free loans, they must include the details of any mandatory credit fees. And if an ad says anything about the speed of approvals, they must include a statement that this is subject to responsible lending inquiries and checks. All of this information must also be stated in plain language that is clear, concise, and understandable. So lenders need to think carefully about their audience and how they are advertising. Lastly, the information must be prominent, so it can't be in fine print. So for example, a billboard on the motorway with a lot of fine print will be unlikely to pass the test, as all the information that's required to be displayed would be almost impossible to read.
That's so true. There's also another really important change that consumer advisors will probably want to be aware of. I think especially if they advocate for clients who are struggling with debt and who may not have understood the agreement. Do you want to tell us about that?
Yeah, that's right. So going forward, when lenders advertise in a different language, they need to provide the key information about the loan in that same language. You'll hear more about that on the talk and disclosure, but it's an important change to be aware of if you have borrowers whose language isn't English.
That's fantastic. Okay, Miriam, do you want to talk us through the don'ts? What are lenders absolutely not allowed to do when they're advertising?
So in terms of don'ts, lenders cannot say or even imply that they won't inquire into or take into account the borrower's circumstances when considering a loan. They also can't advertise that a loan has already been approved if inquiries into the borrower's circumstances haven't been completed. So the regulations provide some words or phrases that aren't allowed to be used anymore. So for example, bad credit okay, or no credit checks, as these types of phrases give the borrower the impression their circumstances don't matter. However, changes to the way lenders must do affordability assessments will require lenders to specifically ask certain questions about a borrower's circumstances going forward.
That's great. Thank you for the clarity around that. Hey, now let's talk about the changes that apply to fees.
Sure. So many of you will be aware that credit or default fees a lender charges cannot be unreasonable. A reasonable fee only compensates the lender for their costs or losses they incur, and those fees need to be closely connected to the activity for which the fee was charged. The general rule with fees is that lenders cannot make a profit from the fees they charge. So this rule is already in place. However, from the 1st of December, lenders are required to keep records about how they've calculated their fees. These records must demonstrate that each fee is not unreasonable at the time it was calculated, and the records must be kept for 7 years and be provided to the Commission should we request them. However, please be aware that it's only the Commission or the dispute resolution schemes that can request a lender's fee records.
Well, that's great that lenders have to keep records proving their fees are reasonable, but what can an advisor do if they think a lender's fee is too high or seems unreasonable?
Yeah, look, that's a really good question, Sonia, particularly if they can't request the records themselves. So if you come across a fee that seems too high to you, for example, fees that seem high when compared to another lender's average fee for that activity, you should complain to the lender about it. So as Wendy will mention when talking about the new due diligence duties, directors and senior managers are now personally responsible and liable to make sure their systems and processes are compliant. And this includes ensuring that their fees are reasonable. They should take your complaint seriously, and you should also let us know as well.
That's good. Now, I know that the fees need to reflect a lender's costs and their losses, and that lenders need to be able to point to an activity that caused the cost or loss. They have to be specific about what they call their fees. Do you want to talk to us a little bit about that? How does that work?
Yeah, sure. Look, so an establishment fee, for example, must reflect the costs incurred for establishing the borrower's loan, and an administration fee must reflect the cost of administering a borrower's loan. Lenders also can't charge fees for nondescript things like miscellaneous or other. They must be able to describe what the fees relate to.
So what does that mean for enforcement? Does this law change mean enforcing the rules will be easier?
Yeah, we think so. So historically, the Commerce Commission has had to spend a lot of time and resources requesting information to determine whether a lender's fees were reasonable. So now lenders will have an obligation to keep records that demonstrate that their fees are reasonable. And although we'll still have to check whether these are accurate, these records will be a good starting point. Fees are also not something a lender just gets to set and forget. So businesses change and grow over time or get more effective with new technology, and therefore costs and losses will likely change too. So fees need to be reviewed when a lender becomes aware or ought to be aware of a change that is likely to impact the reasonableness of a fee. Lenders must also keep records of these reviews.
Okay, so what about percentage-based fees? How does a lender decide whether they are reasonable simply based on a percentage?
So the Commission considers percentage-based fees run a high risk of being unreasonable. It's unlikely that a percentage-based fee will accurately recover allowable costs. So it's good to know that where a lender outsources the collection of debt or enforcement of a loan, almost all collection and enforcement costs passed on to the borrower are default fees and are subject to reasonable fee rules. So where a loan is assigned to a collection agency or third party, the assignee becomes the creditor and all fees it charges are subject to reasonable fee rules. And also on that note, other fees charged by third parties, like a broker, for instance, need to be passed on at cost, and the lender cannot add a marginal profit to it along the way.
So what does that mean for advisors?
So if someone comes to you for help and is concerned about whether the fees they've been charged might be too high, you can certainly tell them that they should query this with the lender. And as mentioned earlier, the lender should be able to explain the types of activity that give rise to the fee. You can also point them to our website, which has information about credit and default fees. The borrower can also make a complaint to the lender or contact the lender's dispute resolution scheme if they need some assistance on how to go about addressing it. And imagine a lot of you also advocating for your borrower in those kinds of situations. And it's great that you do that.
Thanks, Miriam. That's really helpful information, and good to hear what you think can be done when an advisor thinks a lender's fee is unreasonable. So then, would you like to give us a bit of a summary about advertising and fees? What do you think the key takeaways are? What do we need to be thinking about when it comes to advertising and fees?
Yeah, Look, so with advertising, advertising has to comply with the new standards, and it's part of the lender's responsibilities that it can't be misleading or deceiving. Lenders also can't use words that lead the borrower to think the lender won't consider the borrower's circumstances or financial position. And if they advertise a regular price, they also need to show the total costs. And with fees, the new rule is that lenders need to keep records showing that they calculate their fees, how they calculate their fees to make sure they are reasonable. And if they need to review them, they need to review them when there's been changes to their costs or business that might affect how those fees are charged, and make sure that they're staying reasonable.
That's fantastic, Miriam. Thank you so much. And thanks for taking the time with us today. We really appreciate the knowledge that you're able to share.
No worries.
So, thank you. And so if you've got questions relating to fees or advertising, remember there's a survey at the end and you can pop your questions in there. Then we'll spend a week or so answering all those questions, and they will form the information that we're able to share with you at the in-depth seminars. I'd like now to hand over to Wendy Blennerhassett. Wendy's a principal investigator in the credit branch at the Commerce Commission, and she's going to take us through the new requirements for due diligence and certification. Hi, Wendy.
Hello, Sonia, and good morning, everyone.
Wendy, I understand there are new duties being introduced that will require directors and senior managers of lenders to have personal responsibility for ensuring the lender is compliant with the CCCFA.
Yes, so from 1 December this year, every director and senior manager of a lender will have a personal obligation to exercise due diligence to ensure that the lender complies with its duties and obligations under the CCCF Act and regulations. Now, this puts a duty on directors and senior managers to ensure that a lender has adequate compliance systems and processes in place to meet the Act's requirements. And it encourages senior figures to drive a culture of compliance within a lender from the top down.
So what does that look like in practice? Are things going to be much different to how they are now?
Okay. Well, the duty of due diligence requires directors and senior managers to take reasonable steps to ensure the lender's systems and procedures are compliant. So directors and senior managers are expected to take reasonable steps to ensure that staff follow the rules, that the lender has adequate monitoring systems in place to check the systems are working as designed, that system deficiencies are identified, and that the lender rectifies those deficiencies within a reasonable timeframe. If directors and senior managers fail to take reasonable steps to ensure a lender complies with the Act, then from 1 December this year, they can be held personally liable for penalties of up to $200,000 and to contribute to any statutory damages that the lender has to pay. Now, importantly, directors and senior managers cannot be insured for or indemnified against any penalties, which means they need to pay them out of their own pockets, giving them real skin in the game. And what's more, their liability doesn't end when they leave the company. Directors and senior managers can still be held liable for failure to exercise their duty of due diligence when they were a director or senior manager of a lender they worked at previously. So Sonia, these are pretty big incentives to make sure that things are as they should be, and that the lender's systems are adequate and don't create systemic issues that can cause harm to borrowers.
That's really good to hear. So Wendy, who does the duty actually apply to?
Sonia, the duty applies to directors and senior managers of lenders. Now, as we all know, a lender is a person or business that provides credit under a consumer credit contract. And this includes mobile traders if they meet the definition in the Act.
And so are directors just the people listed on the company's office entry?
It's a good question, Sonia, and the answer is no. Generally, a director for these purposes is someone who has responsibility for managing, directing, or supervising the management of a lender's business and affairs. So it's not just the named directors on the company's office register. The duty also applies, for example, to sleeping or silent directors and those who hold equivalent positions in entities other than companies. The actual job title or designation doesn't matter. It's the role performed that is crucial. The question is, does the person behave like a director? Do they exercise the powers and functions of a director?
So what about senior managers? Who is considered a senior manager?
Okay. A senior manager is someone other than a director whose position allows them significant influence over the management or administration of a business. So who is a senior manager will differ from business to business. It will depend on the business's size and structure, and it will also depend on the nature of credit the organisation provides and how responsibilities are allocated. What matters is the actual role the person performs and the amount of influence the person has over the business, not the job title or the way the relationship is actually structured.
Thanks, Wendy. That's quite a substantial change to the law. So bearing that in mind, what does it mean for our consumer advisors and their clients?
It's a good thing, Sonia. It means that those with the power to drive compliance within lenders will have a personal incentive to familiarise themselves with the lender's obligations under the Act and regulations, and to ensure that the lender has adequate systems and processes in place to meet those requirements. This should make the job of helping borrowers a little easier and lead to better consumer outcomes. The Commission's guidance to directors and senior managers recognises that complaints and complaints data are ways that lender can identify where things might be going wrong. Lenders with diligent directors and senior managers should have robust monitoring systems and processes in place so that the directors and senior managers hear about the issues and problems affecting clients. And if they're presented with evidence of the failure of systems and procedures, the Commission's guidance recognises that directors and senior managers may need to ensure that the lender undertakes an investigation into the root cause of the problem. So if you advocate for people struggling with debt and make complaints to lenders about the problems you encounter, your complaints should be taken seriously. If you encounter the same issues with the same lender, this might be a systems issue. You should make a complaint and provide as much evidence as you can. If you don't think your complaints are being taken seriously, for instance, you don't get replies to your emails or answers to your questions, let us know and consider making a complaint to the lender's dispute resolution scheme.
Thanks, Wendy. That seems like it might have a big impact on promoting compliance with the law. I think now would be a good time to talk about another substantial change to the law, which is the requirement to be certified. Do you want to tell us about that, please?
Absolutely. So the new requirement to be certified is compulsory from 1 October this year. It applies to all lenders and mobile traders that currently provide consumer lending and to new lenders who start after 1 October. So from 1 October, lenders and mobile traders that were not previously registered on the Financial Service Providers Register, the FSPR, will need to be both certified by the Commission and registered on the FSPR before providing consumer lending services. Lenders that were already registered on the FSPR on 1 October will have to get certified at their next FSPR annual confirmation. Now, there are exemptions for some lenders, such as banks, who already have a similar requirement with the FMA. The purpose of certification is to ensure that the directors and senior managers of lenders and mobile traders are fit and proper persons to hold their positions. When all the directors and senior managers are assessed as fit and proper, the company will be certified. The Commission considers assessment criteria such as moral and financial integrity and reputation, and competency and capability to perform the role. If a company has multiple directors and senior managers and one of them fails, the company might not be certified until that person has either been removed or replaced with someone who does pass the certification standard. Now, just a couple of things to note. There's a fee that must be paid for certification, and certification generally lasts for 5 years. After 5 years, the directors and senior managers will be reassessed and certification must be renewed.
So how can someone check whether a lender or a mobile trader is certified? How do they do that?
Okay, well, it's very easy, Sonia. You can look up their company name on the FSPR. You should see a tab called Financial Services, and on that tab, it will show if they provide consumer credit and also their certification status. Now, just be aware that not all lenders and mobile traders need to be certified by 1 October. When they need to be certified ties in with the date they need to renew their FSP registration. But by October next year, all lenders and mobile traders will need to be certified.
So that's very, very good to get that clarity. And just a note that while there has been a date change to 1 December for most of the changes that are coming in at the moment, the certification begins, because it runs through in line with their FSP regulation, started on the 1st of October. Yeah. So Wendy, I wonder if you could talk to us about what happens if a lender or a mobile trader is providing that consumer credit and they're not certified, or they break the rules around certification.
Well, as you might expect, there are penalties for breaching the certification requirements. The court may order payment of penalties if a lender provides consumer credit without being certified, if they represent that they're certified when they're not, if they don't notify the Commission of any changes in their circumstances that they're required to, or if they provide false or misleading information in an application. The Commission can certify lenders with conditions in some circumstances, and those conditions will be able to be seen on the FSPR. It can refuse to certify lenders if it's not satisfied each of their directors and senior managers is a fit and proper person to perform their role. Without that certification, the lender cannot offer consumer credit or mobile trading services. The Commission can also suspend or cancel a lender's certification if it receives information about a material breach of a condition, or information that leads it to believe that any one of the directors or senior managers is no longer fit and proper to perform their role. If it suspends a lender's certification, they cannot offer consumer credit or mobile trading services until the suspension period ends. If the Commission cancels a lender's certification, they cannot offer lending or mobile trading services from the date of cancellation. Continuing to offer services in these circumstances can result in a court ordering the lender to pay a fine of up to $600,000 for a corporate entity or up to $200,000 for an individual.
So then what does this law change mean for consumer advisors who are helping people in debt?
Well, Sonia, first, knowing that lenders are certified to provide consumer credit should give you some confidence that the lenders, directors and senior managers are fit and proper persons to hold those positions. Second, if you help someone in debt with a loan to a provider that isn't certified, that's a red flag and you should look a little deeper. Check the FSPR as mentioned previously. Remember, if it's in the first year of certification, not all lenders will be certified at the same time. They have a year to do that in line with the FSP registration renewal. But if you do check and they're not certified, you can always ask them when they need to be certified by.
That's fantastic, Wendy. Thank you so much for giving us that information. We're really grateful that you were able to share your knowledge with us and take the time to talk with us today.
You're welcome.
Thanks, Wendy. So now we're going to hear from our Chief Legal Counsel about disclosure. I'm very, very pleased to be able to welcome Crystal Uden. Thanks, Crystal. It's lovely to have you with us.
Thanks, Sonia. Hi, everyone. This is my 6th year at the Commission, and I've been working exclusively in the credit space in that time. So you could say that I live and breathe the stuff. It's my pleasure to talk to you today about the upcoming disclosure changes. Now, disclosure may not be the most exciting subject, but there are real consequences if lenders don't get it right. So it's important that they know what and when to disclose, and that similarly, you know what they need to be disclosing.
So, Crystal, before we get started on what's changing, I wonder if it would be good to remind everyone what the current disclosure obligations are.
Yeah, absolutely. So there are 4 core types of disclosure currently. That's not including the standing disclosure obligations. But the 4 core types are initial disclosure. That's disclosure of all of the Schedule 1 information that's relevant to the loan. There is continuing disclosure, which is generally the updating information that needs to be disclosed every 6 months. There is variation disclosure, which applies when a borrower and a lender agree to vary the contract, or when the lender just varies the contract on their own. And there's also request disclosure, which is when the borrower or you as their representative ask for copies of certain documents. So those are the 4 core types of disclosure we have, and we have some new ones coming. Sonia, it's your turn for a question, and you have to get this right because I've asked you before. How many new types of disclosure are coming?
Now, I know the first time you asked me this, I did have to have a think about it, but now because we've been talking to lenders about this for so long and so often, I know that it's 3. There are 3 new types of disclosure.
That's absolutely right. And don't worry, I'm not going to ask you to name them all. I can do that for you. They are financial mentoring disclosure, which I'm sure you're all happy to hear is coming. There's also dispute resolution service disclosure coming, and disclosure that must be provided before debt collection. So there are 3 new types of disclosure coming, and I'll talk about those. I'll also talk about 2 other areas that are sort of disclosure-esque. They're areas that lenders will need to get ready for, and they are some rules coming in about extra disclosure when lenders advertise in another language, and also some clarity around what must be disclosed when the loan is varied. So there are 5 things that I'm going to talk to you about today. Please don't feel that you need to take notes. We recently released some update and disclosure guidelines, and pretty much everything I'm going to talk about is set out in those guidelines with even more detail. They're available on our website, and Penny is right now going to pop in the chat box a link directly to those guidelines for you. So I'll start with the 2 sort of non-disclosure-esque new obligations coming in, and then I'll turn to the 3 new types of disclosure. So firstly, I'm sure you'll all be interested to hear what's in store for lenders when advertising in another language. Miriam has already spoken about what information must be disclosed in the actual advertisement itself. This is about what must be disclosed afterwards. Now, disclosure as we know it is prescribed information. It's information that must be disclosed at certain points during the contract. So for example, I mentioned initial disclosure before. That is information that must be disclosed before the borrower enters into the contract. And we know the consequences if that disclosure is not provided is very high. That's section 99(1)(a), which provides that if initial disclosure is not provided, then the lender cannot recover its fees and interest until the proper disclosure is given. Now, for those core types of disclosure, what lenders must disclose for each is very prescribed. The new requirement is, if lenders advertise in a language different from the one that the lender used in their loan agreement, and the advert is less than 6 months old, then the lender may need to offer information about the loan agreement in the advertised language. The key here is the lender may need to give enough information to enable the borrower to make an informed decision about whether to enter into the loan. Now, what is disclosed here is at the lender's discretion. It's not prescribed. Obviously, if a lender wishes to translate all of its documents into the advertised language, then that is an option. But our caution to lenders here has been that they need to ensure that the translations they provide are accurate. If the translation provides a different impression or is even different to the loan document terms, then the version which is most favorable to your client, the borrower, is the one that will apply. So I'd recommend here that you check any translated documents which are given to your client against the loan documentation to ensure that they match, because if they don't, then the term that is more favorable to your borrower is the one that will apply.
And Crystal, I know we've talked about this a lot, that the Responsible Lending Code also recommends that where a lender suspects the borrower doesn't have a good understanding of the language used in the loan documents, that the lender must have processes in place to pick that up, and they have to offer the borrower information about the agreement in the language that the advertisement was in.
That's right. Thanks, Sonia. And of course, everything I've just said about what information must be provided to borrowers about loan agreements also applies equally to what must be provided to guarantors about their guarantees if the advertisement is in a different language.
So then, Crystal, what's the consequences if the lender fails to provide that information in the other language?
Well, this could lead to a pecuniary penalty of up to $600,000. So it is really important that lenders have processes in place to prepare for this. So moving on to variation disclosure, which is the one where I said there was some clarity coming about what needs to be disclosed. What's an example of variation, you may ask? Well, an example is where the contract is varied following an agreement between the lender and the borrower to change the loan following a hardship application. Now, what lenders had to disclose when a contract was varied has never been prescribed. To date, lenders have had to disclose the change and the effect of the change by being told that they must disclose the full particulars of the change. From 1 December this year, the CCCF regulations now also provide that if the variation affects the credit limit, the annual interest rate, the total interest charges, and all the payments required, then the lender must disclose that with the information prescribed by the regulations. In addition, if the contract is a high-cost consumer credit contract and the variation affects the credit fees and charges, then that must also be disclosed. And again, the information that must be disclosed is set out in the CCCF regulation. Our revised disclosure guidelines set out a fair bit on what we consider lenders must disclose when there's been a variation. So I highly recommend that you have a look at Section E of those guidelines.
And so, Crystal, when we're thinking about the consequences for failing to provide proper variation disclosure, are they as high as the advertising failure that you mentioned before?
It's a great question, because actually the consequences are higher. So if the lender doesn't provide variation disclosure as required by the Act, then the lender can't recover its interest and fees until they've made corrective disclosure. That's Section 99(1)(a) again applying here. So in addition to those consequences, lenders could also be liable for a fine of up to $600,000. So moving now to the new disclosure that's coming in. The first two types of new disclosure I'm going to talk to you about, I'll talk about them at the same time. They are financial mentoring disclosure, that's you guys, and dispute resolution disclosure. Now, they both carry the same consequence. If the lender fails to disclose the required information, then that's an offence and can lead up to fines of up to $600,000 per offence. For financial mentoring disclosure, from 1 December, if the borrower defaults, makes a hardship application, and or the lender declines a high-cost loan application, then the lender must disclose to the borrower information about the availability of financial mentoring services. Now, the regulations set out specifically what the lender must disclose about those services. And if you come to our deep dive session on this, you'll hear in particular about what must be disclosed when and where. Now, there are 2 points that I'd make about this. The first point is, with financial mentoring disclosure, the regulations require lenders to provide details of an MSD-funded service. Because the disclosure is tailored to a borrower's particular circumstances, that is, it's triggered by something the borrower has done, for example, a default, then the lender should be able to point the borrower to a financial capability service that is funded by the MSD and in the local area to that borrower when the disclosure is provided. And the second point I'd say to that is, if the lender is, for whatever reason, for example, there's no local service available. So if the lender is unable to provide a locally based service to the borrower, then the lender could direct the borrower to FinCap, as that is a MSD funded financial capability service that applies nationally. Now, for dispute resolution service disclosure, from 1 December, if the borrower makes a hardship application, complains about enforcement action, or makes any other complaint that's covered by the regulations, and it's pretty broad here, then the lender must disclose information about their dispute resolution scheme. So again, the regulations set out specifically what the lender must disclose, and there are even requirements about where the lender must disclose it in the disclosure document.
Yeah, so for example, that might have to be at the top of the front page or something.
Yeah.
So that's super useful. Thanks, Crystal. I'm really looking forward to hearing about those new debt collection disclosure obligations as well. Do you want to talk about that now?
Yeah. So that's the third and final piece of new disclosure that's coming in. And I'm sure a lot of you will be pleased that this one is on its way. So from 1 December again, before debt collection starts, the lender must disclose certain information. There are some exceptions. So payment reminders aren't a debt collection step, so they don't count. If the goods are at risk, then the lender won't need to provide disclosure beforehand, etc., which makes sense, right? Because then the goods will be at even more risk. Now, the regulations, again, this is regulation 23 this time, set out specifically what the lender has to disclose. But the key things that will need to be disclosed are the debt collector's details, the lender's contact details, information about the underlying contract, enough of that information so that the borrower can identify it. So for example, how much the loan was for, what the loan was for, etc. And it's important to note here that the lender is not required to provide the borrower with a copy of the contract, but you or the borrower can request that document at any time. So if that's requested, then the lender must provide it. Other information that needs to be disclosed is information about the amounts of the debt that's currently owing and any amounts the debt collector will be charging. And finally, the lender must also disclose, or the debt collector on behalf of the lender must also disclose information from the last continuing disclosure statement if the lender's previously been required to send those. So for example, the information provided would be how much was owing at the last statement, how much is owing now, etc.
That's great. So then if we think about the consequences, if the lender doesn't provide this new type of disclosure, what are they? What does that look like, Crystal, if they're not compliant?
So for each failure here, it would be an infringement offence, and the lender could be fined up to $30,000 per offence. But we would also want to know about this one, not just because it's an infringement offence, but because we consider that responsible lenders will be and should be ensuring that this type of disclosure is provided, especially in light of their responsible lending obligations when a borrower defaults. Lizanne also wants me to make sure to let you know that if you have a complaint about a debt collector, you can complain about that debt collector directly to the lender. This is because lenders are responsible for the conduct of their agents, and the lender responsibility principles apply. So don't be shy if there's any issues with a debt collector. You don't need to go to the debt collector directly. You can go to the lender. So I've talked about 5 disclosure or disclosure-esque areas that lenders are going to need to be ready for come 1 December. There are a couple of things to take away. The first is, I should probably say one more time, grab yourself a copy of our disclosure guidelines. They've been updated and contain a lot more information together with some helpful examples that we hope will be useful. The other thing I'd say is it might be worth asking next time you have a new client how they knew about financial mentoring services and how they came to know about your service, if you don't ask that already, of course. You could ask them if lenders have ever provided information about financial mentoring services when they missed a payment or made a hardship application. And if they didn't, it might be worth finding out why. And lastly, you may want to let your client know that they can ask for information about a loan in the advertised language if they see an ad about credit. The lender only has to provide it if they think it is necessary to assist the borrower. But if borrowers know it's available and they ask for it, then we would expect responsible lenders to provide the translated material if the borrower themselves is saying it would be helpful. So I hope that's been useful to you, everyone. Thanks for your time, and tēnā koe.
Thanks, Crystal. That's been incredibly useful. And I've seen some really, really good questions coming through. So Crystal, I'm looking forward to working with you again as we do the in-depth seminars in a couple of weeks.
Awesome.
Thanks, Crystal.
Thanks, Sonia.
So the questions that come through on the chat, we will filter those through so that they inform the in-depth webinars. But remember, you've also got the opportunity to fill in the survey at the end, and that can give you a chance to make sure that your questions are answered. So I can see Jean-Marie joining us, and I'd like to hand over to Jean-Marie. Welcome. Jean-Marie is a senior investigator in the credit team here at the Commission, and today she's going to talk to us about the credit reform changes that impact on lenders' responsible lending obligations. It's a really important one. Welcome, Jean-Marie.
Thank you, Sonia. Good morning, everyone. I look forward to giving you more information around responsible lending. So first of all, as we all know, lenders are required to comply with the lender responsibility principles found at Section 9C of the CCCFA. These include the obligations to make reasonable inquiries before agreeing to lend to a borrower, so as to be satisfied that it is likely that A, the loan will meet the borrower's requirements and objectives, i.e. that the loan is suitable, and B, that the borrower will make payments due under the loan without suffering substantial hardship, so i.e. that the loan is affordable. So from 1 December 21, lenders will have a few additional obligations when making these inquiries, which are set out in the new regulations. One change that will benefit yourselves as consumer advisors is that lenders will need to make those records available upon request for free within 20 working days. You do not need to provide a reason why you want the records. Lenders must provide them, and if they don't, they could face a very large penalty. I'll talk a bit more about record keeping a little later and what you should expect to see when you receive them. Some of you may be aware that the Responsible Lending Code has also been revised. The code provides guidance on what responsible lending looks like in practice, and most of it comes into force on 1 December.
Yes, I can see Penny's popped a link to the code in the chat so people can access it easily. Jean-Marie, there's some really interesting changes around when a material change is made to a loan that will give, I think, more clarity and more certainty. Can you tell us more about that?
Yes, so coming into effect from 1 December is the requirement to make affordability and suitability inquiries when a material change is made to a loan. So the term material change will be defined and covers increases to the credit limit or where the lender is looking to make another advance of money that they didn't already take into account.
Jean-Marie, I know lots of people will be thinking, aren't lenders already expected to do this? So, I wonder if you could talk about this.
Yes, at the Commission, we would normally expect lenders to be doing that, making new affordability assessments with top-ups, but the law change makes this requirement explicit.
There's also a new process which is set out in the regulations, and I know that'll be of great interest to everyone watching this seminar. Tell us about that.
Yes, so from 1 December, lenders must follow the process set out in the regulations when making the affordability and suitability assessments required under the Act. A failure to comply with the regulations will be a breach of the relevant responsible lending principles, which now imposes penalties of up to $600,000.
Wow. Hey, so we hear a lot about suitability. Do you want to talk to us about what does that actually mean in this context?
Yes, Sonia, so suitability is really about making sure lenders provide the right financial product. So they will need to ask the borrower questions to guide that decision, such as what they plan to use the money for, how much money they need, and how long they'd like to pay it off. Once gathered, the lender needs to assess the information and decide whether they can meet those needs with the financial products that they offer.
So then what can an advisor do if their client wanted to borrow a certain amount or needed a certain amount, for example, to buy a particular item, but the lender extended more credit than was required or more credit than the client had asked for? What happens then?
That is a good question, Sonia. So as mentioned, the lender must make reasonable inquiries about the purpose of the loan. This specifically includes asking the borrower about how much they want to borrow. So from 1 December, lenders will have to keep records about the information they gathered and how they assessed it. Those records need to show the amount requested, and if more was loaned, record a reasonable explanation as to why. If you consider the amount extended was not suitable for your client, you can complain to the lender. The lender may need to reduce the credit limit and or compensate your client if financial detriment was suffered.
Do you want to tell us about the affordability assessments and what lenders will have to do? And I'll just quickly, if I may, apologise for my neighbour's dog, which is barking. So I'm sorry if that's disturbing anyone. Jean-Marie, tell us about the affordability assessments.
The new regulations prescribe the types of information that lenders need to gather and assess to be satisfied that the borrower's income will exceed their expenses, including the loan being sought. So when assessing the borrower's income or expenses, lenders will no longer be able to simply rely on what the borrower tells them. Now they need to verify the information if possible and base it on reliable evidence. They need to ask a lot of questions about the borrower's income and expenses, including specific questions about any foreseeable circumstances that might affect the borrower's income.
It's a really big difference for lenders and also for borrowers. What happens if a lender can't obtain reliable evidence?
Well, Sonia, where it's not possible, the lender needs to decide whether the source and amount of income is realistic. When making that decision, they need to comply with the responsibility to exercise care, diligence, and skill. So when assessing expenses, lenders must follow a two-part process. First, they must make an initial assessment to estimate the expenses from asking questions or obtaining reliable information. This assessment should also consider any missed expenses. So for example, health issues that are now revealed because the borrower receives a disability allowance, but health expenses were missed from the initial inquiries. And secondly, they need to verify the expenses. Lenders need to obtain reliable evidence. So for example, 90 days worth of bank statements, or by using appropriate benchmark. If necessary, they must then adjust expenses to reflect a reasonable minimum cost if they have been underestimated. So just a note about benchmarks. These can be used for expenses that are benchmarkable, meaning they must be based on reliable statistical data. If lenders choose to use a benchmark, they must take the higher of either the initial estimate or the benchmark figure. So for example, if the initial estimate for food was $200, but the benchmark for that expense for a borrower in similar circumstances was $250, then they will need to use the higher amount.
Something I was really interested to hear about was that lenders must account for expenses that borrowers are unwilling or unable to give up.
Yes, Sonia. So for example, gambling or tithing or money the borrower is saving for a specific purpose, they cannot ignore those costs if the borrower does not want to or can't give them up. Once the two steps of the initial estimate and verification are done, the lender then makes the final assessment to decide if the borrower's income exceeds their expenses or they need to add buffers to income and the expenses. This is to account for any overstatement of income or underestimate of expenses, or for any unexpected expenses that might arise after the borrower gets the loan. So in short, lenders cannot lend when the results of the inquiries show that the borrower is in a cash flow deficit.
That's a really useful high-level summary. Thanks, Jean-Marie. I think it's really good, important to note that the regulations are much more specific.
Yes, it's also important to remember that the affordability and suitability inquiries don't just apply in relation to loan contracts, but also to certain add-on products such as extended warranties, repayment waivers, and credit-related insurances in certain circumstances. The regulations also include specific details about how to make those inquiries.
Hey, so now would you like to tell us about record keeping? Can advisors ask for copies of records?
Yes, definitely. So from 1 December, lenders will be required to keep records about the inquiries they make, including the results of those inquiries. So they have to assess the information they gather to work out a budget surplus. So what can you expect to see? The records must demonstrate how the lender has satisfied itself that the loan product was suitable and affordable, and clearly showing how they arrived at that decision. There is no prescriptive format that lenders must use, but it cannot be confusing, misleading, or deceptive. They will also have to show how they worked out the suitability and affordability of credit-related insurance financed with the loan. Borrowers or their representatives can only ask for those records from 1 December 2021 on new agreements or top-ups from 1 December. That is important to remember.
Yeah, that makes sense because that's when the law changes come in. Hey, so then what are the consequences if lenders don't follow the rules and lend irresponsibly?
Well, Sonia, the consequences are substantial. For activity that breaches the lender responsibility principles from 1 December 2021, lenders will be subject to penalties up to $600,000 for a company and $200,000 for an individual, plus statutory damages equal to the cost of borrowing. So all the interest and fees owed under the loan.
So then what can an advisor do if they've got a client who's struggling and they don't think the lender worked out the affordability correctly?
Well, you can complain to the lender if you have a client who got a credit limit increase or new loan after 1 December 21 and the loan was unaffordable according to your calculations. It's a good idea to provide as much information about your client's circumstances as possible and some evidence that shows that they are experiencing hardship. Be clear about what you would like the lender to do about it. Later on, the dispute resolution scheme will talk about how they can help when you aren't getting anywhere with the lender or you don't agree with what they have offered.
That's fantastic. Thanks, Jean-Marie.
Thank you, Sonia. I hope that was helpful.
Very, very helpful. Now, responsible lending is super complex, and Jean-Marie, we appreciate your expertise. Remember, if you've got questions, the survey at the end gives you the opportunity to ask as many questions as you'd like, and that helps us with what to present at the follow-up sessions, which are being held over the 26th and 28th of October. So that's a very high-level summary of the key changes that are coming up. Remember, there's details in the handouts, and we're holding those in-depth webinars. We'll be recording those sessions as we have with this one, so you can refer back to them at any time or watch them at your convenience. Now, we're really excited to share with you our new Red Flags resource to support you in your work. Many of you will know Lizanne. Hi, Lizanne. It's lovely to have you here. So I'm thrilled to welcome her today to share with you the new and improved resource. We've emailed everyone an electronic copy that went out with this invite and then again this morning. Penny has just popped a link to it on our website in the chat. So I'll hand over now to Lizanne. Thanks, Lizanne.
Great, thank you, Sonia. Kia ora, everyone, and welcome to the session to launch the new Red Flags. Now, this will be a very familiar resource for many of you that was introduced in 2017. Red Flags is hot off the press, and copies will be available after the seminar. But I'll just be providing a brief overview of the resource today.
So for the very few, I suspect, number of our listeners who aren't familiar with Red Flags, do you want to tell us a little bit about why the Commission produced this resource?
Yeah, sure. It was developed for consumer advisors and advocates helping people in debt because it wasn't easy to spot lender behaviour that was unlawful. This provided a way for advocates to do something about the problems they saw every day. It also enabled the Commission and the community to work better together to help protect vulnerable borrowers from ongoing harm when they borrow money. The recent law changes meant that many of our resources needed updating, and this included Red Flags. But we also took the opportunity to see how people were using it and what could be improved. Earlier this year, we went on a fact-finding mission to check this out. We held online workshops with some financial mentors and their trainers, and we also held workshops internally with credit investigators and legal staff to hear about some of the red flags they saw when investigating cases.
Yeah, it was so good to have the financial mentors give that input because they're the ones that are using it. So Lizanne, when you were working with them, co-designing this, what did they say? What sort of feedback did they give?
Yeah, well, they really like the simplicity of the resource and that it's available in hard copy. Another useful feature was the section on the law. And this time mentors asked for more information about the law to better understand what the lender's obligations are. They also wanted guidance on next steps to help them understand what can be done to help their client. They wanted easier ways to report the harms they see to the Commission. And we took that all on board when redesigning the new red flags. And now what we have is a much more comprehensive credit law guide designed with your input.
So Lizanne, how do consumer advisors use the new red flags?
Well, it's designed to be a part of an advocate's workflow when working with clients or interacting with lenders. For advisors that don't advocate for clients per se, it can help provide tailored guidance to some of the most common credit-related issues. For example, a financial mentor might be seeing a client who presents a new debt, and you know they're in a cash flow deficit, and you suspect the loan may have been made irresponsibly. You go to the appropriate page on how lenders must do affordability assessments, which can prompt the questions you may need to ask your client, such as whether the lender asked the right questions or gathered the documents they needed to. And from there, you can see whether any hardship your client experienced was caused or worsened by that loan. There is a section on next steps that provides a bit more detail on the actions to take, including actions of recourse if working with the lender isn't working.
And Lizanne, when I was looking through it, it looks like they've been simplified into two main sections.
Yes, that's right. The law section sets out the lender's obligations, and the red flags are the issues most commonly experienced, including some guidance on what to do about it. You'll see that each area is set out in the same way. It's important to say, though, that this is not legal advice telling you what you should do, but it helps you decide whether or not you think the lender may not have complied with the law. And then you can decide on the best course of action for your client's circumstances.
And I see there's a section on vehicle finance.
Yes, this was in response to many requests for help and guidance in this area. We have provided some information on the Consumer Guarantees Act to help you if your client has found major faults in a recently financed car. Following that, we have a table on key dates that you need to be aware of. It's very important to know the date the agreement started or the date of the top-up. This might determine how you can deal with the debt or the lender's conduct, because the best course of action could depend on when certain provisions came into force. Now, Crystal mentioned earlier that there are new rules with disclosure for debt collection. Now, we have provided some of the information debt collectors will need to provide before debt collection starts. Now, this is just some of the information. For the full list, you could see the CCCF Amendment Regulations 2020, and we've just popped a link to that in the chat function.
It's so useful to have that list. So, it's really good to see that list of resources.
Yes, we've provided some of the phone numbers for the dispute resolution schemes to make things easy, and also important websites like the Financial Service Providers Register, or the FSPR as it's commonly known. Now, some of you will be well versed with this register. Now, Wendy mentioned earlier that all lenders providing consumer credit will need to be certified by the Commission, and you can check this out on this register. But remember, just keep in mind that there will be a transition phase before all lenders are registered and certified. We have provided the link again to that in the chat function. And at the end, we have a glossary. Some of the words in this document are defined terms, and having this reference can help provide further understanding, such as what relevant expenses mean when lenders must calculate relevant expenses.
Oh, that's incredibly useful because it is legal language and that becomes important sometimes. I can see also, Lizanne, that you've developed a much easier way to report harmful issues and lender conduct through a notification email.
Well, Ment has asked for an easier way to tell the Commission about the harms they see, or just even to tell us about general credit market observations. We understand that making formal complaints can sometimes be time consuming, and we also understand that some clients can be reluctant to make a complaint. You'll find this information on the bottom of each red flag page. With the notification option, all that is required is the name of the lender if relevant, and a high-level summary, which could be a short paragraph of why you believe they have not complied with the law. With the new laws that are now in place, and those that will be soon, this information will be very important. So as you can see, this is a far cry from the first red flags, and we hope it will provide you with something that can become a part of your workflow when helping clients with burdensome debt. We'll be going through the red flags in a lot more detail in the deep dive sessions later on in the month. And following those sessions, we will be providing ongoing support through workshops online and including face-to-face when circumstances allow. Well, Sonia, I think that's my time.
That's fantastic, Lizanne. Thank you so much. And on behalf of everyone, thank you for all of the work that you put into this. It's an incredible resource, and I know I've really enjoyed seeing it come to life.
Right.
Thanks, Lizanne. So you can order hard copies of the red flags for yourself or your service by emailing us at credit.advocacy@comcom.govt.nz. And Penny's put a link to that email address in the chat function. So our next session is all about complaints and where you can go if your client has a problem with their lender, their credit contract, or anything to do with the lending process. As you probably know, there are 4 dispute resolution schemes in New Zealand. All of them are free and all of them are independent. They investigate complaints, respond to inquiries, and provide guidance on all sorts of financial issues. So I'm very pleased now to introduce Zoe Presley, who will provide a brief summary about how the dispute resolution schemes can help. Welcome, Zoe. It's lovely to have you with us.
Tēnā koe, Sonia. Kia ora koutou, ngā mihi nui kia koutou katoa. Thank you very much for the welcome and for inviting me to speak to you briefly. You'll be pleased to know it's briefly after all that amazing information. I am here on behalf of all 4 dispute resolution schemes. That includes the Banking Ombudsman Scheme, which is where I work, the Insurance and Financial Services Ombudsman Scheme, Financial Dispute Resolution Service, and Financial Services Complaints. We are all aware that that is quite a mouthful, and I'm here to tell you that it's actually easy to contact us and we are here to help. We can answer your questions, any question, we can look into complaints, or we can help get people to the right place. Our website links will all be appearing soon in the chat function, but here is a brief video now about how we can help. Thanks, Penny.
Kia ora. Did you know there are 4 dispute resolution schemes in New Zealand who can help with complaints about financial services? We are free for consumers, independent, faster than court, and we are the experts in resolving complaints about financial services. Accessibility is important to us. We offer translation services so you can speak to us in a language you prefer. A financial service is a business that has anything to do with money. This includes banks, insurance companies, investment advisors, lenders, mortgage brokers, credit unions, international money transfer services. When might you need our help? Maybe you have an issue with a loan repayment. Your KiwiSaver financial hardship application was declined. Your car was repossessed. Your insurance claim was declined. Something's gone wrong with your bank. You bought something from a door-to-door salesperson and it hasn't arrived. Simply, maybe you've had an unfair experience. We can help with these and with many other complaints. It is our job to help find a resolution. Remember, our service is totally free. It doesn't matter which of the schemes you call, we will make sure you get to the right place. Contact us. We're here to help. Financial Services Complaints Limited. Banking Ombudsman Scheme. Insurance and Financial Services Ombudsman. Financial Dispute Resolution Service. Ka kite anō.
Thank you very much. One of the reasons we're here today in this seminar is that the Dispute Resolution Services and the Commerce Commission care about the same issues. Lending complaints are common, and the red flags are also complaint red flags, things that we will be looking out for and considering when we investigate complaints. And by the way, congratulations to the Commerce Commission for all the work put into developing and expanding on that red flag resource, which is really amazing. So if you see a red flag, as Lizanne's been talking about, tell the Commerce Commission, because their job is to lead that industry-wide change. They are there to enforce the CCCFA changes and to avoid the problems that your clients face, and hopefully to stop things from going wrong on a large scale. But as we all know, on an individual basis, things can go wrong. And that's what we, the dispute resolution services, do. We are there to help look into those specific issues and the circumstances for individuals. And if we can, we will help put things right for them. Sometimes putting things right will be facilitating a settlement with a lender. Sometimes we will make decisions that are binding on a lender or a bank, and requiring the lender to reduce the debt or pay compensation to your client. And if, when we've taken a look, we are satisfied that everything is okay, we'll tell you this too. So making a complaint is easy. All you need to do is call us, ring us, or send us an email, or go to our website and fill out a form, or even write us a letter. It doesn't matter which one of us you contact, even though we're aware it can be a bit confusing, all those names. We will make sure you get to the right place. There is no wrong door, and it's free and independent. When we get the complaint, we'll take it from there. We don't expect you to know all the details or which section of the Act has been breached. We can work through that together. We don't need you to have all the information required to investigate the complaint. We can often get that information from the lender. We just need to know that you have a concern about something the lender has done. While we do receive complaints from financial mentors, your clients can also contact us directly. We do our best to make the process as easy as possible, and we can communicate in the form that is easiest for you or your client. We all have translation services, as the video said, so people can speak to us in the language they feel most comfortable with. As you know and have heard today, the Commerce Commission are planning some more webinars later this month about the CCCFA changes, and they've invited us to present, which is great because we'll have the opportunity there to talk about the cases and share the stories that we see that raise some of those red flags. And you'll have the opportunity to think about those examples and to ask us questions. I understand the Commerce Commission will be sending you a survey, so please fill it out and tell us what you want to know more about, because we want to make this worthwhile and to provide the information that will be the most useful for you. So I know that's been a lot to take in. We think the changes are really exciting. We welcome them and we are here to help. You can contact us anytime. Kia ora tātou.
Kia ora, Zoe. Thank you so much for that. And thanks to everyone for watching this webinar. We know it's not as good as being at a seminar in person, and we're really, really grateful that you've taken time out of your day to join us. So if you need any of the handouts or want more information or a copy, either an electronic one or a hard copy of red flags, just email us. We're looking forward to hearing from you, and you can send us an email using the email address credit.advocacy@comcom.govt.nz. So I'll do a very quick summary before we close. There's lots of guidance on the website with more coming, so keep checking and make sure your details are up to date, because we do email everyone when new guidance is published. Those handouts are a really useful summary, and if you didn't get them, email us. And hold the date, 26th and 28th of October. Throughout those 2 days and different times, we'll be running 6 deep dive sessions, one on each of the key subjects. Each of these are 45 minutes long and will be created based on your questions. So please, when you close this window, it will invite you to head to a survey where you can pop questions you'd like answered or tell us about what information you'd like covered. When a window comes up, click continue to go through to the survey. And thank you. It allows us to make sure that the next sessions, our webinars provide you with what you need to know. So in the next few days, you'll receive an email from us with a link to attend one of these in-depth seminars. There's one on each of the 6 areas. So you can choose to attend them all. You can choose to attend some of them, one of them, or none. It's totally up to you. And again, if you wish to have a copy of red flags couriered to you, just send us an email. So now I'd like to close in the way we started with karakia. Uruhia, uruhia, uruhia ki te uru tapanui. Oh, my apologies. PJ's here. In that case, I would like to hand over to our kai whakahaere Māori, PJ Devonshire, who can do the honours for us. Thanks, PJ.
Tēnā koe Sonia, nā mihi kia koe tēnā karakia. Mihi ana ki a koutou katoa, ko piri mai I te wenerei tāno ki tēnei rangi. He mihi nui ki a koutou I tautoko o nā hāpuri o te motu. Tautoko nā hāpuri o te motu ki a kawe taka ki te he. E mihi nui ki a koutou mō tēnā. Nō reira, te piri tēnei kōrero ki tēnā o Sonia, ki a whakakapi e tēnei hui, tēnei wā. Me nā whakaaro tonu ki te wāhinaro. Hoi anō. Whiti ora ki te tipua, whiti ora ki te tāpito, whiti ora ki te kawiariki. Whiti ora tāwhiwi atu ki a koe e rongo whakairia ki runga ki tēnei. Ki tēnei hui ki a tautonu mai te rangi Māori ki a wātea, haumi hui e tāe ki. Kia ora, tēnā koutou.
Kia ora, PJ. And thank you to everyone for attending again. I hope you have a lovely Friday and a wonderful weekend. Haere rā.